Good afternoon. We are today with Professor Laurence Shore. He is joining us from Milan. And there is no need for introduction for Professor Shore. He is a well-known arbitrator, counsel, professor on international arbitration, commercial law, and investment law. He has written extensively on these subjects. And now he's going to talk with us about arbitration law and practice for last year for the United States. The floor is yours, Professor Shore.
Thank you so much, Professor Dr. Yeşilırmak. It's a great pleasure and honor to be back and speaking about U.S. arbitration law and practice, this time review of the year 2025. My only regret is that I'm not in person in Istanbul, and that will need to change in the future. It is, of course, one of the world's greatest cities, and it is a great university that Professor Dr. Yeşilırmak teaches at Haldun, and it is truly an honor to be back with you. My plan, with the permission of Professor Yeşilırmak, is to first speak about some practice and arbitral institution background in the United States in 2025, and then speak about two sets of cases that have been particularly prominent in 2025. One set concerns sovereign states who've had arbitration awards delivered against them outside the United States, and then enforcement actions have been occurring inside the United States. And I think there's some very important global issues that attend to sovereign states. And then in the final section, I will address some of the most important commercial arbitration decisions in the year 2025. And there have been some highly significant commercial arbitration decisions. I'll plan to speak for about 50 minutes, and then at the end, if Dr. Yeşilırmak wishes to, as he has in the past, pose some difficult questions, I will try. So let me begin with trying to give some description of the arbitral institution network in the United States, which I think gives a lot of flavor to the actual practice of arbitration in the United States. So there are three major U.S. international arbitral institutions. The most important in terms of numbers and attention is the International Center for Dispute Resolution, the ICDR, which is the international arm or division of the American Arbitration Association. Now, the ICDR is actually relatively recent. It was founded in 1996. The AAA is one of the oldest arbitral institutions in the world. It was founded in 1926. And for many decades, as you can tell by that division in the years, the AAA, which had always has had a huge domestic arbitration docket, also managed at the same time its international docket. And here's the practice point. As a consequence, for a long time, and there were many complaints from international arbitration practitioners about this, international arbitration in the United States looked a lot like domestic arbitration in the United States. But from the mid-1990s, that changed. To give you just one example of how it looked like domestic arbitration, the AAA, for many decades, and it was only about 20 years ago, provided that co-arbitrators, or the two arbitrators nominated by the parties, they could actually be advocates for the party that nominated them. They didn't have to be impartial and independent. Now, of course, that's gone by the boards, but there's still a legacy of that. But it helped in getting rid of that legacy that the ICDR was founded, and there was a really determined effort to make international arbitration in the United States look like international arbitration seated anywhere else in the world. To give you an idea of the scope now, in 2025, the ICDR had 725 international arbitrations filed. Now, while not all of them were seated in the United States, most and virtually all were seated in the United States, because you really wouldn't be going to the ICDR unless you were also going to the US, which also meant in international cases that if a US party was involved, the US party had sufficient bargaining power to bring you to the US and for you to also be accepting the ICDR as the arbitral institution administering your case. And to give you an idea of what that 725 means, in 2025, the ICC had 894 new case filings. The LCIA had 362, Stockholm Chamber 213, and by the way, that was a record year, 2025 for the Stockholm Chamber. SIAC, Singapore International Arbitration Center, which of course now rivals the ICC in terms of popularity of the arbitral institution, 886. And finally, HKIAC 582. So it gives you some idea of the scope. ICDR, extremely important globally, not quite at the level of ICC. And it's also not quite at the level in another sense, because of course, the most represented nationality in ICC arbitration is US American parties. So many US parties, presumably with bargaining power, nonetheless, if they have a US seat, are choosing ICC. So ICDR popular, but not immensely so. 73 international mediations filed with the ICDR in 2025, maybe not as much as one would expect. Here's an interesting point which reflects, I think, maybe US style arbitration practice. The median time to a final award from the filing of a case in the ICDR is 20 and a half months. So again, one might expect something a little quicker. However, in ICD arbitration, where you often have an American party involved, you probably often have document production as a feature where you might not as much in other jurisdictions. Principal industry sectors, and here's an interesting point. If you go to other major international institutions, energy and construction I think Dr. Yeşilırmak will confirm, are always 1 and 2. In the ICDR, technology is the leading sector for international arbitration case filings. Construction is number 2, financial services, number 3, and energy, number 4. So it is a little bit surprising, I think, that you would see energy, where, of course, especially now, the US is, of course, touting itself as the great energy exporter for the world, especially with recent issues in the Gulf. We have energy not the primary industry sector. That technology gives you an idea, I think, about where arbitration practice is going in the United States, very much in the pharma, life sciences direction, along, of course, with anything that speaks of kind of big data. The most popular seats in the United States in the ICDR administered framework, which is the largest, it's not New York, it's Miami. Miami, New York, Los Angeles. Again, a reflection, I think, of where things have gone. Many international arbitrations in the US under the ICDR administrative framework emanate from Latin America. And many of them are in the construction and financial services area rather than the energy area. The headquarters for the ICDR, however, is New York City. Number 2, which is less important but still important, and again gives you an idea of how arbitration is practiced in the United States, is JAMS, the Judicial Arbitration and Mediation Services Institution that was founded in 1979. And here again is a reflection of how the United States arbitration practice can be tightly linked to litigation practice in the US. So JAMS was founded in 1979. The international arm of JAMS, JAMS International, was only founded in 2011. So fully 15 years after the ICDR saw the light and went international, JAMS remained a very important domestic US arbitration institution. And in fact, JAMS, its arbitrator roster from the beginning was retired US judges. And so, of course, you would expect retired US judges to handle arbitrations in the way that they would handle their courtroom. And in fact, the experience of many, including, I should say, my experience of JAMS, was that a retired judge handling the case as it would be in her or his courtroom. Now that's changing. JAMS itself is seeking to be more international. In 2025, JAMS had 22,000 filings. 308 were international cases. 200 of the 308 were arbitration cases, 100 mediation. Again, what that signifies is JAMS, not a big player, but not an insignificant player, but still leaning towards a domestic orientation where you have retired US judges and you have a heavy mediation dose of international cases. Most frequent JAMS seats: New York, Los Angeles, San Diego, San Francisco, Miami. And then finally, it's important to mention, I think, an institution for which we don't have data, but which has had an influence on US arbitration practice, and that's CPR, the International Institute for Conflict Prevention and Resolution, like JAMS and ICDR, headquarters New York. JAMS International, the headquarters is in London. CPR was founded in 1977. Now, you can see JAMS and CPR, founded within 2 years of each other, that in the late 1970s, the United States litigation practice was becoming so expensive, so ferocious, that there was a move to create alternative dispute resolution. And there is where JAMS and CPR came into play. Now, CPR was founded, in effect, by corporate general counsel. And so it still has a very corporate general counsel feel. It certainly doesn't have many international arbitration cases. Probably, again, we don't have the numbers, still has a much more important mediation sector or mediation emphasis. But CPR does have an outstanding set of international arbitration rules that Robert Smith, a very prominent US arbitration practitioner, had a principal hand in drafting. And they have been influential in some ways. For example, CPR has tried to implement a system whereby parties, everyone knows that the parties to international arbitration want to nominate their arbitrator. They know their arbitrator is meant to be impartial and independent, but they still want to have a hand in constituting the tribunal. CPR acknowledged this. You can still have a hand in constituting the tribunal. However, the arbitrator that you nominate will not know who nominated him. And it has had a very interesting psychological dynamic because, of course, you would think, this will be attractive to parties. They get their arbitrator, in effect, but the arbitrators, the tribunal once constituted, they will have a greater degree of freedom because they don't know who nominated them. As you might expect, it doesn't quite work that way because what parties really want is to have an influence on the tribunal by their nominee knowing who nominated him or her. So CPR thought this would catch on, and as we all know, it has not. But at least it was an interesting effort. CPR has a long list of what they call neutrals. Again, think about the use of that term. You only see it in United States arbitration practice. Again, I'm going to say that unless contradicted by Professor Yeşilırmak. And the reason, and hearing no contradiction yet, the reason that term is used is exactly what I was referring to before. Remember that when U.S. arbitration practice, was founded by the AAA, the two co-arbitrators did not have to be impartial and independent originally. That meant the only neutral was the chair of the arbitral tribunal. So the legacy of that term still being used by JAMS and by CPR, even in their international divisions, reflects the old US practice that there is only one neutral on a tribunal of three. I should say CPR has a long list of neutrals on their website, and it is very international in approach and in for the individuals on that list. They do come from all over. They do have international backgrounds. So I wanted to give that arbitral institution flavor of US practice. And then there's one practice development initiative, extremely important, that was published in 2025 by the American Arbitration Association, ICDR, that I wanted to mention. And it's critical given where our arbitration is going. And of course, it has to do with artificial intelligence. The president of the AAA is the former Chief Justice of the Michigan Supreme Court. Her Honor, Bridget McCormick. I believe she became president of the AAA in 2023. She immediately wished for the AAA and ICDR, the international division, to be at the forefront of using AI tools. And I think what's interesting is that the ICDR, AAA ICDR, I'll just say ICDR, the ICDR is one of the few institutions that I know of. In fact, I don't know of any other institution that has actually published guidance for arbitrators' use of AI tools. And I believe that President and CEO, I should say CEO McCormack, has been extremely useful in pushing this initiative. She's been an avid supporter of the responsible use of AI in arbitration, recognizing that there may be huge efficiency advantages, but at the same time recognizing that there needs to be some guidance for arbitrators. And she's not talking about counsel here. Of course, that still may be to come. And the purpose is to encourage arbitrators, ICDR arbitrators, to use the technology while adhering to their professional obligations under the AAA Code of Ethics for arbitrators, and thereby to ensure fairness, integrity, and confidentiality. And let me just say for a moment that it is also striking that the AAA has a code of ethics for arbitrators, because now there are initiatives through various international bodies. I hear it in conferences all the time about a code of ethics for arbitrators. There's guidance that the IBA, has published for parties, in addition, of course, to the evidence rules. But there's not been a specific code of arbitrators, ethical code of arbitrators that other institutions have taken steps to produce. The AAA's had one since 2003. It's a good template, but the interesting thing is that CEO McCormack has said, so we want AI being used, which is, again, interesting. We think the advantages for the arbitral process, especially efficiency, but at the same time, arbitrators have to be mindful of their professional obligations. And so here's how the guidance, these are the points, I'll just quickly run through them before getting to the case law. So arbitrators must check the accuracy of information received from AI tools, preferably by going back to the primary source. So therefore, if an arbitrator uses a summary of a case, an AI summary of a case, as an initial step to understand something, the arbitrator must nonetheless go back and check the actual case report. So there has to be a checking function. That's canon one above all. What the guidance, ICDR guidance, is saying is this is going to be a very well-constrained use of AI tools. Secondly, what the guidance says is, you as arbitrators, if you use these tools, you must take steps to understand how to use them properly. That is, if you don't know anything about the platforms, whether they be Claude or Harvey or any of the popular AI legal platforms, you must take steps to understand how those platforms or those tools can be useful, and how there is a limit and what the limit is to their utility. And here's where I think is where the rubber hits the road for the guidance and the use of AI tools. I think this is something that will it's not one is a self-regulatory, well, they're both self-regulatory, but one remains self-regulatory and one remains disclosed. And here's what I mean by that. What the guidance says is, if an arbitrator uses an AI tool for legal research or analysis of evidence, the arbitrator must take great care that his decisions nonetheless reflect independent evaluation and reasoning. So that is something that the arbitrator must take care about. But the guidance goes beyond that. If the arbitrator determines that his use of an AI tool really affected the process, he or the reasoning underlying his decision, he must disclose that to the parties. Now, I cannot imagine that happening anytime soon from an arbitrator, and I've never heard of it happening because of this phrase, if the use of the AI tool materially impacts the process or the reasoning underlying the decisions. Because if it does materially impact, then I would suggest it's being improperly used and relied on. So there are still some things to work out with the guidance. One final point is arbitrators should not put confidential information into tools that don't protect the data. So that's something that really will, of course, should, I should say, rather than will, be a slight obstacle to arbitrators using AI tools if they're following the guidance, because it, of course, would need to be a paying system. You can't just simply put it into ChatGPT, the platform that's available for anyone's use. So that's the important practice development or initiative. I think it's important because I think inevitably others are going to have to follow. They won't be, I mean, this disclosure canon is not going to be followed, I don't think, but there's going to be something here where in part, maybe a new international code of ethics for arbitrators will certainly include provisions on AI use. So with that, let me move to the two tiers of very important decisions, court decisions that occurred in 2025, that were issued in 2025, coming as a result of arbitral awards. And the first decision that I want to mention is the only US Supreme Court decision of note regarding international arbitration in 2025, and that's CC Divas versus Antrix Corporation, which was a June 2025, so 1 year ago, US Supreme Court decision. And the reason that you don't see a sovereign name in the title is that Antrix is owned by the Republic of India. of the three leading state sovereign U.S. International Arbitration Court decisions, two involve the Republic of India. And the only Supreme Court decision, Dives versus Antrix, involves the Republic of India because Antrix owned by the Republic of India. So here's the interesting part. The arbitral tribunal outside the United States found that Antrix breached a contract, okay? The panel awarded a huge sum, more than US dollars, 560 million, now up well over $1 billion with interest. Dives petitioned the United States District Court for the Western District of Washington, so Washington State, to confirm the award, and the District Court confirmed the award. Pretty standard stuff. Breach of contract, Antrix loses, claimant just goes to confirm. But the Ninth Circuit Court of Appeals reversed, and it reversed under the Foreign Sovereign Immunities Act of 1976, which is basically the act that will control wherever sovereigns are sued in the United States. And the reason why the Ninth Circuit reversed, because under controlling law in the Ninth Circuit, a minimum contacts analysis was required for personal jurisdiction, even under the Foreign Sovereign Immunities Act. So there are provisions about immunity and exceptions to immunity under the Foreign Sovereign Immunities Act. Clearly, under the Act, one of the enumerated exceptions to foreign sovereign immunity is an arbitration agreement. And nothing more really was needed than that. However, because of Ninth Circuit prevailing law, the Ninth Circuit had no option but to say it still had to be shown that within the Western District of Washington jurisdiction, that court had personal jurisdiction. That is to say, the state of Washington had personal jurisdiction because there was a minimum contacts of India with that jurisdiction. And the Ninth Circuit found that there wasn't. But the result in the Supreme Court is the exception applies and no minimum contacts analysis is needed. So I'll just read to you this critical paragraph from the holding in the US Supreme Court. The Foreign Sovereign Immunities Act comprehensively regulates the amenability of foreign nations to suit in the United States. The immunity and jurisdictional provisions form the foundation of that scheme, and Congress tied them together. So whenever an exception applies, the Foreign Sovereign Immunities Act strips immunity and grants jurisdiction. And you don't read an additional minimum contacts requirement into the Foreign Sovereign Immunities Act. Here we have an arbitration agreement and nothing more is needed. And I'll come to why that's so significant when I come to the next case, which is a DC Circuit case later in 2025, Deutsche Telekom again versus the Republic of India. And this is arguably a more interesting case. So Deutsche Telekom wins a $100 million award in Switzerland. Switzerland's the seat. UNCITRAL arbitration, Germany, India, bilateral investment treaty. The District Court for the District of Columbia confirms the award. Deutsche Telekom brings that award, which is against a foreign sovereign, but is a commercial and is a treaty arbitration, but is under UNCITRAL. So it brings it to the United States. And India argues for dismissal in the district court, and it does so on two bases. One, it should be dismissed because of sovereign immunity, and two, its substantive defenses were not taken into account. The DC Circuit explains why those arguments were ineffective and the award will be enforced. In one respect, the DC Circuit says the dismissal, the Foreign Sovereign Immunities Act dismissal that India wanted, that goes nowhere. But India is entitled to have its substantive defenses considered. So the DC Circuit reverses in part. So it says it is the case that India is entitled to have its substantive defenses heard, even though its attempt to have the case dismissed is rejected. And here's what I wanted to say about the Foreign Sovereign Immunities Act, which is so important. Under that act, 28 United States Code 1605 A6B, an award made pursuant to an arbitration agreement with a treaty potentially governing the agreement is going to be upheld. An objection challenging the existence of an arbitration agreement is jurisdictional, but there was an arbitration agreement that clearly existed. Foreign Sovereign Immunities Act won't touch that. That means to say there's an exception to foreign sovereign immunity because there's an arbitration agreement and the treaty, under the treaty, Germany and India. So confirmation follows on that basis. However, an objection that the dispute falls outside the scope of the arbitration agreement counts as a merits defense, and India is entitled to have that defense heard. Now, that's what's so interesting here. Remember, this is a BIT award. It was made in Switzerland because it's an UNCITRAL, not an ICSID case. So the seat, it's an award under the seat, under the New York Convention. And what the DC Circuit says, the terms of the BIT, the Germany-India Bilateral Investment Treaty, indicate that arbitrability has not been exclusively delegated to the arbitrators. So no dismissal on the basis of personal jurisdiction because of the FSIAA, but India is entitled to have the court, because it's an arbitrability issue, consider its argument that this dispute did not involve an investor or an investment covered by the bid. That's an extremely interesting result when you have many states challenging whether there's a proper investor or usually a proper investment under the treaty. And the DC Circuit here says, ultimately, that's for the court, unless there's something else in the treaty that indicates arbitrability has been exclusively delegated to the arbitrator. So that's what I wanted to say about DTEK. And then finally, it's important to mention this because it's an EU matter. The final set of cases that I wanted to mention come under the rubric Blasquet versus Spain. And so these are ICSID cases. under the Energy Charter Treaty, 5 UK companies sued Spain. They won a series of awards. One of them, of the 5 or 4, was euro 28 million. European courts, having declared that similar awards are invalid because of Achmea and its progeny, prompt the companies to come to the United States to seek enforcement of the award. And unsurprisingly, this is an August 2025 case. Unsurprisingly, when Spain makes a jurisdictional challenge that under the FSIA, the DC Circuit rejects that challenge. But it's an interesting one because Spain says there was no valid arbitral agreement. And Spain says that there was no valid arbitral agreement because of the case law from the European Court of Justice, Achmea and others. The DC Circuit had previously in 2024 rejected that argument. So what remained then? Well, what remained then were merits findings, because that's all Spain had to argue. But of course, the court won't touch a finding on the merits because it doesn't concern jurisdiction. But here again is a fascinating aspect of this case. Spain says, if you make me enforce, if you make me pay this award, I will be in violation of EU law because it will be regarded, the payment to Blasket will be regarded as impermissible state aid under European law. And what the district court says, because this case will go up on appeal, is up on appeal. What the district court says is, well, comity does not provide a disgruntled party with the runaround of the Foreign Sovereign Immunities Act, even if this makes Spain at odds with its EU law obligations. Basically, what the district court says is, well, it's too bad. If the EU wants to do something to you, that's your problem. But here, you have to pay. We're going to enforce this award. And of course, if you don't pay, then the claimant starts looking to attach Spain's assets in the United States. But the key aspect here is, given the conflict, first, the court says we find it highly unlikely that you'll be punished by the European Union if you pay an award that we say you have to pay. But if you are, that's your problem. That doesn't mean that we are going to rip our statute apart. So those are the important sovereign state cases. And because it's commercial arbitration and it's intriguing, but there are fewer statutes involved, I can be a little quicker, but there are 4 decisions in 2025 that I wanted to bring to your attention because each of them concerns an interesting aspect of US arbitration law and practice. The first is a case that was decided by the Second Circuit, United States Court of Appeals for the Second Circuit, which has its main courtroom in New York City, molecular dynamics versus spectrum dynamics. And here's the interesting part. Molecular loses an arbitration seated in Geneva. The parties' contract provided that New York courts would have exclusive jurisdiction over all matters concerning the arbitration. So what Molecular does is file in the Southern District of New York to vacate the awards. Now, that'll sound strange to you, to all of you who have had, of course, courses from Professor Yeşilırmak, because you know that you really can't do that under the New York Convention. And in fact, the Southern District of New York said you can only move to vacate at the seat, at the foreign seat in this instance in Switzerland. So even though the contract says New York courts have exclusive jurisdiction over all matters, that won't work. Now, the Second Circuit says the result is correct. There's no subject matter jurisdiction, but it actually reasons in a very complicated but I think important way. And for anyone who wants to know about the recognition and enforcement mechanism under the New York Convention, this about 38-page ruling from the Second Circuit is a terrific lesson. And for me, it was incredibly helpful to be reminded of these points. Hopefully, I was just being reminded. What the Second Circuit says is that it is correct that the New York Convention concerns chiefly enforcement of foreign awards and does not contemplate a petition to vacate a foreign-made arbitral award. So it's silent on that, is what the Second Circuit says. So as a matter of US law, which is the Federal Arbitration Act, and that would be 9 USC section 203, the petition to vacate does not fall under the convention. The key words are fall under the convention, which is what you must have for subject matter jurisdiction in the US. Since there's no provision for vacating a foreign award in the United States, the matter doesn't fall under the convention. And then the Second Circuit goes on to explain what the US calls the difference between primary and secondary jurisdictions under the convention, as well as the distinction between recognition and enforcement of an arbitral award under the convention. Secondary jurisdictions may only decline to enforce an award under Article 5 of the New York Convention. Only primary jurisdictions can vacate an award. But here is where the Second Circuit, in a very delicate way, corrects the SDNY, the court below. The Second Circuit says, but we don't decide whether it's consistent with the New York Convention for parties to designate by contract one country as the seat and another as the venue for vacator. That we don't touch. Our case is, the case brought to us is section 203, which means, does it fall under the convention? It doesn't fall under the convention because the convention doesn't contemplate vacator outside the seat. Now, that may be a distinction without a difference between the SDNY and the Second Circuit. And the Second Circuit is just saying, we don't know whether you can do that under the New York Convention, but we do know you can't do it here. You can't do it under section 203 because it doesn't fall under the convention. It's a very delicate, as I say, distinction. I'm not sure what others would do with it, but it is an extremely useful ruling to have at hand to understand how the New York Convention is meant to work and the difference between recognition and enforcement, which I won't go into and which is dealt with in the standard US judicial way. Something so important is put in a footnote. So the other cases are, I have to say, not as intriguing, but Southern District of New York, 2025. It's a non-signatory case. And I raise it because New York law on bringing a non-signatory into an arbitration is, I would say, troublingly flexible. And here's not necessarily one of the more flexible cases. Sucafina seek to compel arbitration against a non-signatory. The STNY says, yeah, we're going to compel the non-signatory to arbitrate. And it does so on an agency theory. And the interesting thing is, unlike, let's say, France, where a parent-subsidiary relationship is really an invitation to a French-seated tribunal or a French court to say, well, we think here the non-signatory clearly was aware of the arbitration agreement. If it had a hand in negotiating it or terminating the contract or performing the contract, we're going to pull them in. New York says, no, you need much more. The record supports the finding that the non-signatory is bound to arbitrate under an apparent agency, an apparent authority agency theory. But it's this last thing that I want to mention. The other theories under New York law to enforce an arbitration agreement against a non-signatory are incorporation by reference, assumption, alter ego, and equitable estoppel. And if they had failed on agency, Sucafina still would have had an equitable estoppel argument, which basically means anything the court wants it to mean. It's basically a fairness principle. Does the non-signatory benefit from the underlying contract, the contract containing the arbitration agreement, such that we think it's fair, that it's equitable estoppel, that they should be compelled to arbitrate? That's the troubling part of New York. Final two cases, Westinghouse, also SDNY. It's not that I only believe that New York matters. One of the cases that I mentioned before, DTEC versus India's Third Circuit case. But SDNY is where a lot of the action is in enforcing or compelling arbitration in the United States. Here, the defendants moved to compel arbitration and stay litigation. The claimant argued that there was waiver and the parties had not engaged in negotiation precondition to arbitration. And here again is, this is an ICDR clause, very important, because the court says it's just for us to determine whether an agreement to arbitrate exists, not for us to decide whether the disputes are arbitral or not because of the ICDR clause, which specifically empowers an arbitrator to decide issues of arbitrability. So if you have an ICDR clause in the United States, it already means that the arbitrator, if there's an agreement to arbitrate, the arbitrator decides issues of arbitrability, such as waiver, preconditions, and therefore the defendant's motion to compel arbitration is granted. The final decision is an interesting one because it's a complicated fact pattern. Arbitration in Chile, the construction company loses. It has, in the meantime, spun off its operating business, and the winner moves to enforce in the United States against the successor in interest to the company that lost the arbitration, seeking to attach shares of the successor of interest that had nothing to do with the arbitration and the assets of the company that arbitrated, the original company. And the Third Circuit, again, not the, here's the Third Circuit, sorry, opinion, not the Second Circuit or the SDNY. The Third Circuit holds a court may exercise quasi-in rem jurisdiction to enforce a foreign award in an action to collect on an already adjudicated debt. There's no requirement to show minimum contacts. So the crucial point is, if Webuild is a successor of interest to the original award debtor, its shares, which had nothing to do with the arbitration, but are accessible to the court in Delaware, those shares can be attached. And that's an intriguing result when you have a successor of interest and you have an existing arbitral award for which there is an already adjudicated debt. So, Professor Yeşilırmak, I did not tell the truth. I said I would stop at 10 to the hour, and it's 3 to the hour. I apologize for speaking so much, and in your hands.
No problem. Thank you very much, Professor Shore. It's only 7 minutes, 8 minutes over the time. But we are not counting the time. We enjoy a lot with the company and the information you provided to us. There are a small number of questions this time. We are not going to ask you very difficult questions, hopefully. In light of the ICDR guidance and arbitrators' use of AI tools, how do you think arbitral institutions should draw the line between permissible technological assistance and impermissible delegation of adjudicatory reasoning to AI?
So I think that's an intriguing and important question. I think, in effect, the other arbitral institutions are doing it in the same way they would speak of the secretary to the arbitral tribunal. Certain tasks can be performed, they have to be well defined, but the secretary can have no role in the analysis of the evidence and the reasoning underlying the decision. I think in that way, not to make secretaries to the tribunal into robots, but I think that's what arbitral institutions outside the ICDR would say. It is apparent, that we have addressed this. However, as we know, I mean, it really isn't so apparent. And I do think that there will be so much concern ongoing about what counsel are doing. If, for example, counsel are using, super AI tools and large document production exercises, who's checking that, first level review versus third level review, all those types of things which have come up in other ways. I think there will be much more attention given by institutions to exactly what arbitrators are using the AI tools for. So I can hardly believe, and I don't understand why it got through this disclosure canon in the AI guidance that, you have to disclose if use of the tool materially impacted the process. That I find, I would find that hard to believe, and no one should be admitting that because that should not be happening. But it's unclear. I was recently counsel in a case where the tribunal actually asked counsel to prepare the procedural history because they said, we recognize that arbitrators have to write the award, but this is not something we want to spend time doing. No kidding. And so the council had to do it. I think many arbitrators are probably already using AI tools to write the procedural history. I think it's a long-winded answer to say I think it'll have some influence. I actually am surprised that the ICDR hasn't made a bigger effort to popularize their being at the forefront here. Although I think President McCormick does travel a lot and does try to say, look at what we've done. And you should do something too.
Sure, sure. But the problem is you have to create your own agent at the moment. You cannot use the common tools for AI for confidentiality reasons.
Absolutely. No, but I do believe that I would be astonished if there aren't at least 10% of, I will say, international arbitrators with, who are reasonably busy full time, who aren't taking advantage of an AI tool. And one only hopes that it is one of those data protection AI tools. Yeah.
Sure, sure. Second question is still on AI. Do you think disclosure of AI use by arbitrators should depend only on whether it materially affects the process or reasoning, or should parties be informed whenever AI is used in connection with legal research, evidence analysis, or award drafting?
So again, interesting. I would say it more should be whenever it's used, because material impacts is really a problem. That means that I do believe that means if it's material impacting, well, first, I'm not quite sure what that material impacting means, but to me, it doesn't sound appropriate. Um, Again, the whole idea of a secretary to the tribunal is that all the tasks are defined and consented to by the parties. If you don't have a secretary, but you're using an AI tool, for example, to well, I would see, I've never used an AI tool, so I'm shooting in the dark here a little bit. But if you've used it, for example, to prepare for a hearing by saying, some 400-page brief, I've run it through, Harvey or Claude, as I'm told, these are two popular legal platforms. And it assisted me in getting ready for the hearing. If I were a party and I heard that, I would say, well, we'll do a summary for you. I'm not, you want a summary, we'll do a skeleton, we'll do a summary. I'd be pretty unhappy about hearing a reliance on a tool which I think makes a lot of mistakes from, what I've seen. But I do think if you are using the tool, that you should, in the same way that you have to disclose use of a secretary, I think you should disclose use of the tool. Anything you're not doing by your own hand.
All right. So at the end of the day, would the parties say, okay, then we pay you less? You use artificial intelligence, materially affected?
Well, it's something to come. I mean, I have heard from a particularly aggressive client who was, not overly happy with with what he felt was a large fee to pay us and the arbitral tribunal, saying, well, why don't we just give all the papers to, AI and let them, let this AI tool make a ruling. And what's wrong with that? And well, what's wrong with it is, of course, the AI tool is basing everything on, of course, bringing to bear the other cases, and so something that would be remotely comparable. It can see how many times it's been decided one way and so on and so forth. I think it's I- personally, I'd still want, with all the imperfections, a human arbitrator. But it's one of those conundrums. I know one college professor has said, as an experiment, well, you have AI write your brief, and I'll have AI grade it. and then I guess we'll try and get to, what really, what really are the best arguments. But that may depend on who's got the better AI tool. It's like drugs and athletics. Who's got the better chemist who can, help you win the Tour de France? Becomes rather less interesting.
Okay, one last question. In light of the cases on sovereign immunity, do you think US would becoming more attractive forum for recognition and enforcement against states?
Absolutely. The Foreign Sovereign Immunities Act, if you have a valid arbitration agreement, and now we have the rulings, at least of the DC Circuit. Well, cert was denied by the Supreme Court from the DC Circuit's ruling in 2024 on Blasket and Achmea EU. I think it takes a while in the US, that's for sure, but I think the US, as I mentioned, the US is adamant. That's a valid agreement to arbitrate. We appreciate that the EU says that they never agreed to arbitrate because they never could agree to arbitrate. But the US is not clearly buying that. And on that basis, all of these awards, whether they're macula, they all end up going to the US because a European court is not going to enforce. And the US, for all of these states, they all have assets in the US. Now, and so you can always try to attach commercial assets of the states, non-sovereign assets in the US. So I think the attitude of the US courts under the Foreign Sovereign Immunities Act is you have a valid arbitration agreement and you're a state. I mean, unless you have a defense like the one I mentioned that has not been remitted, to the arbitrators, and therefore the court can look at under a treaty whether you have a valid investment, whether you're a valid investor, that type of thing. I think the US becomes the great repository for enforcement against sovereigns. And I don't see that changing anytime soon. And I think there's a real willingness of the US courts, as reflected by the Blasket decision, to enforce these awards. If it looks like an arbitration agreement has been signed, then or in a treaty, that it's been at least properly triggered, then I think it will continue. The U.S. will continue to be an important enforcement jurisdiction against sovereigns.
Thank you very much, Professor Shore. We deeply appreciate. We are grateful for hearing from you the U.S. arbitration law and practice. This webinar is brought to you by Dispute Resolution Center of İbn Haldun University. We are thankful to Professor Yeliz Bozkurt Gümrükçoğlu, Dr. Ömer Faruk Kafalı, and our research assistant Hüseyin Yağızhan Kol. Thank you very much. See you next time.